Committee, Justice Mohammad Mustaq, and today's speaker, Honorable Justice Jayashankar Nambiar, to the dais. Okay, by invoking the blessings of the Almighty, let's start the session. Dignitary on the dais, honorable judges, senior lawyers, President, Kerala Federation of Women Lawyers, members of NGOs, and my friends at bar. Good evening. On behalf of Victim Rights Center, let me invite each and everyone to this session. On the dais, we have today's speaker, Justice A.K. Jayashankar Nambiar, who will be speaking on the topic. Now, moving on to that is, as we know, this session is organized by Kerala High Court Legal Service Committee, and this is to promote the theme of the project, Victim Rights Center, which is a joint project of Kerala Legal Service Committee and KELSA. Now, moving on to today's topic, that is gender justice and constitutional perspective. As we know, gender justice is understood as equal and equitable treatment of women in social, political, and economic domain. Our Constitution puts women at par with men. Constitution has express provision for affirmative actions in favor of women, prohibits any discrimination against women, and also ensures equal opportunity for women in all spheres. Now, we are fortunate to have Honorable Justice Jayashankar Nambiar to speak on today's topic. As we know, he's an excellent orator, a distinguished jurist, and a constitutional expert. And with hope that there is active participation from each one of us present here, let me welcome today's speaker, Justice Jayashankar Nambiar, to speak. Welcome, sir. Thank you.
Thank you, Indu, for those words of welcome. Chairman of the KELSA, my brother, Justice Mustaq, Justice Kausar and Justice Niaz, fellow judges, senior advocates of the bar, junior lawyers, students, ladies and gentlemen. On a subject like this, a crowd like this was also to be expected. And I'm glad that of the people filling this room, the majority are women. And so I want to, before I actually start a discussion on the topic, I'm a little curious as to your views in the matter. And I want to, before I begin a formal discussion on the subject, I'd like to understand what is it that you perceive as gender justice from society. I'm sure all of you would have had some personal experience or some, either in the form of a dispute or some unsavory incident which brings to the fore the aspect of gender bias or gender insensitivity. And normally the reason, or you can attribute such conduct of fellow citizens either to a view that is held in society, a patriarchal view that is held in society, of it being predominantly male-dominated. Alternatively, it could also be because you perceive our laws as inherently unfair, in which case you have a problem with the law. Thirdly, it could also be a situation where you think that your unpleasant experience has largely on account of inadequate state action. So in other words, the government is not there to protect you. The government is not doing enough. So I just want to hear some views from all of you, just two or three of you. And if I may start with the elders and respected seniors in the bar. Sumati ma'am, you're sitting here. Is there just a random thought as to what you think this, gender insensitive conduct can be attributable to? Do you think it is only the general perception in society regarding, or the patriarchal society, or the patriarchal views that are taken by society, or do you think it is something more than that? It is actually an inherent flaw in the law? Ma'am.
I would say that it is not because of the law only, mainly due to the patriarchal system only.
Right.
That the old system of more importance for father and male members in the family, that is still being followed, and that influence is mainly causing half of the problem that we are now facing.
Okay. Somebody from the back? Meera? Anybody? It can be random. Because I was also attending the talk the other day organized by the Lawyers Association in the M.K. Damodaran Hall, and I heard Advocate Shantama and Senior Advocate Simandini ma'am also talk, and she's just entering the hall as we speak. Yes, ma'am.
Lordship, the 3 points that you said, all three have their own relevance. The first being that the society, the patriarchal society, the second being the law, and the third being the government not being able to, the machinery not coming up to it. Because we, as I see it personally, we have sufficient laws, but we don't get them implemented because of the patriarchal mentality of the people who are supposed to execute it. So all three are interconnected.
Okay.
I'm a Christian by birth, and in my community, share of a girl at the time of her marriage is given. We don't call it dowry anymore because it's prohibited. At the same time, the share is not commensurate with the number of daughters and the sons. So there's some kind of bias, and then the judgments have come that allow us to have an equal share. But at the same time, once a daughter is married off, whatever time that may be, the value that is given at that point is considered to be equivalent to the share that's given to the son. Now, if she goes to a court to ask for something better, the fact that she went to court itself is taken against her, whereas a male can go. Similarly, it's about the victims who we find every day in the papers. The attitude of the police when you go to a station to make a report, how they see you, you're the victim. They tell you to compromise. Your dignity and esteem has no value there because you are brought under a system that says that the girl has to always stay one step behind, kind of.
But is that conduct of the policeman in this situation that you described, is it something that is generally to victims in general, or is it only to female victims?
Female victims more so than victims in general.
Okay.
Whereas in the Christian community, when you get married, at least in the Bible it says, when he gets married, he will leave his parents and go with her. Whereas no girl in my community I have seen ends up going to her house. They all end up going to his house. And he never leaves the family, she leaves the families. All contrary to what is said in the Bible. So, I don't know, our society is so entrenched in patriarchy, that there doesn't seem to be any rescue.
Okay, somebody from the students at the back. Anybody? I just want to know what is your perception of gender bias in society, and what do you attribute it to? Do you attribute it to the flawed or unequal laws that are prevailing here? Do you have a feeling that the laws are not equal? Or do you find that the state is not taking adequate action? Anybody, any of the students can answer.
Good evening, sir. So, in my opinion, laws are in fact made by the society in itself. So, when you look at the bigger picture, I think when laws are made by a society which is conceptually flawed by the idea that men are considered to be more, or let's say not considered to be in a higher hierarchy in comparison to women, I think it's the system itself that needs to change. And when the system itself changes, the law would also change. Hello? The law would also change. So I think the society in itself needs to identify the problem and then identify a solution itself, which would be reflected in the laws, as the laws are, in fact, a reflection of what the society thinks. And only when the idea of society, when it comes to men and women and their role in our society, only then can a change in our laws be reflected. And only then can our society in itself change.
Okay. Meera, Kartika, one of you.
I think it's difficult to answer the question in the sense that one thinks of the question as an individual and as a lawyer. Because as a lawyer, when you think of, when you said whether it's a law that's a problem, as a lawyer, I don't have a problem on that because I know I have a remedy to it. But I'm just one among the very few who's privileged to be a lawyer and who can afford to think like that. A good part of the members of the society, especially when we talk about women in general, really think that there is no way out. Oh, that's the law.
Mm.
But
Okay.
of course, as I think I agree with Sumati ma'am, more important than the law, it's the makeup of the society. It's a patriarchal concepts that is ingrained probably even in me.
Yeah.
Knowingly and unknowingly, as you are born, bred, and grew in this society. I think that plays a huge impact.
Okay, good. I think we are all on the same page. I just wanted to ascertain that because the one thing that is most important when you talk about gender justice and feminism is that you need to be clear as to what it is that you're up against. And you need to identify the problem, the root cause of this patriarchal views in society. And so let's start with that. But before that, I would be using this word gender and I would be referring to men and women. And please understand that I use it in a different sense from the sex that you're assigned to at birth. As you all know, sex is something that you're assigned at birth. It's a biological thing. You're either branded male or you're branded female, depending upon your biological construct. Gender, on the other hand, is a social construct. And gender, they say a person is born female, but grows to either a man or a woman, right? So gender is something which is a social construct. It is basically an identity that you adopt as you grow. And for that reason, when we are talking about gender here, we cannot ignore a very valid and a very important group of people, which are the transgenders. And you have to treat them also as male, as men or women, as they choose to identify themselves. So that's one caveat that I would like to add when I talk about men and women. The second is that you have to understand that gender bias or gender insensitivity is not something that's confined to India. It's a universal phenomenon. It's all over the world, and it's only compounded by further things which we call intersectionalities, which is when you have a gender insensitivity or gender bias coupled with a bias against caste, coupled with a bias against a particular transgender or a homosexual or a lesbian. These are all things that can intersect, and together they can make life miserable for a particular person. So I'm dealing here only with the gender insensitivity in a broad way, treating only the men and women. Now, in law, when we talk about gender injustice in society, we are normally referring to one of two situations. One where you have different set of rules for men and women, right? There are rules framed differently for men and women. Alternatively, you could have a same set of rules applied differently to men and women. So one is in the making of the laws, and the second is in the application of the laws. And in either situation, if the woman feels disadvantaged, then you say that there is a problem with the law, and the law is either discriminatory or unfair towards the woman. I believe, however, that there is a third and most important cause which probably explains the first two. And that is a world that is interpreted from a male perspective. Right? And this is very, very important because these are the kinds of... It is when you interpret the world differently from a purely male perspective, your knowledge of the world is gained only from that perspective. And when you gain knowledge from that perspective, you make laws based on that perspective. And therefore, you find that the root problem is, as you all correctly identified, the perception in society, the flawed perception in society, if I can call it. And it is this area that feminism concentrates on. It is this area that feminism targets. And what is ultimately feminism? Feminism is just a theory. And what do you mean by theory? Theory is a term that originates from the Greek word theorier. It means to see. So when you're talking about a feminist theory, you're talking about seeing the world, interpreting the world through a female vision. When you're talking about Marxist theory, you're talking about seeing the world through the Marxist philosophy. So theory is basically seeing the world, and feminist theory is seeing it through the female eyes. Now, what we're attempting in feminism, when you're trying to address the gender bias, is basically trying to tell the world, trying to inform people around you that, look, the perspective that you have about the world, the understanding, the knowledge that you have about various things in the world is flawed because it does not take into account an important perspective. And this is the essence of what we're trying to do when we're trying to combat or trying to beat gender justice. There's a very interesting book, and I would seriously recommend that read to all of you. It's a book by a lady called Carolyn Perez. She's written a book called Invisible Woman. It's a Sunday Times bestseller. And it's a must-read. And I seriously say that all of you must read it because it talks exactly about the root cause of gender bias, and it talks about the gender bias that goes, and the data bias that goes into the making of almost every conceivable system of governance. And it's important. Other interesting reads, now that we're on the books, is there is an interesting book of 1997. It's called The Intrusion. I don't know, many of you may have already read it. It's a book by an author called Sashi Deshpande, and she talks about the harrowing experiences of a young bride and who's just married, and she's talking about the marital rape issue. Another book is by Anise Jung, a 1987 book titled Unveiling India. That's an interesting read because it actually, she does an ethnographic study. She goes among and moves around people who are oppressed, who are, in poverty, and she tries to understand the problems of those women and how the degree of oppression has actually affected their lives. The interesting part of that book is that almost 15 or 20 years later, she came out with a sequel to that book. And that is called the Beyond the Courtyard. And why it is interesting is because she goes back and visits the very same people she had interviewed for the first book, and she wants to find out what happened to the daughters of those women, just so that you can cover the generational gap and see how far we progressed as a society. Now, why the data bias has led to flawed knowledge is because, as we've known, right from the beginning of civilization, whatever forms of knowledge that we have as a generation have got, we've learned from our history books. And you look at any branch of human existence, be it history, be it sciences, or be it the politics, you find that from the earliest point in time, you have been looking at things the wrong way. Let's take the earliest concept or earliest image of a human being that you were taught in your history books. Anybody who's read, avid history readers, if you even the later books, say for example, if you've read *Sapiens* by Yuval Noah Harari, he talks about the earliest human as hunter-gatherers. The earliest human being is pictured as a hunter-gatherer. That's the profile you have of a human being. And what is a hunter-gatherer? He's a person who goes with his spears, his bows and arrows. He goes and hunts animals for food and brings back, gathers the food, comes back home. Now, with this profile of a human being, you have actually developed modules or models of nutrition that will sustain a human being. You have built models about what is the environment that is most suitable for human existence, right? Now, where is the flaw there? Where is the flaw there? The flaw there is, in all of this, you don't take into account the lifestyle of the cave woman. She was not hunting. She was not running after a wild deer. So what was she doing? And why isn't what she was doing relevant to create the profile of a human? So the earliest lessons we get in history, harking back to the caveman and the cave woman, who is conveniently ignored, we find that our knowledge, all of you know those, the twisted ladder structure, the double helix of the DNA. The discovery of the double helix structure of the DNA is attributed or credited to two scientists who have given the Nobel Prize for that, Watson and Crick. But nobody ever knew that years before Watson and Crick discovered this model, the model was actually discovered by a young women scientist called Rosalind Franklin. She's not even heard about. Switch over to politics. You're talking about, let's talk about democracy. We all hail democracy as an ideal form of governance. We've adopted it in our country, democratic republic. Democracy has its origins in Greece. And it's hailed as one of the best and preferable forms of governance. How many of you know that in ancient Greece, the women did not have the right to vote? So what is this democracy that we're talking about? The essence of democracy, we were told, is universal adult suffrage. The place of its origin, women were never given a right to vote. What about sports? Take the Wimbledon. Andy Murray, in I think 2013, was when Andy Murray won the Wimbledon. The British people were rejoicing. Finally, we have a champion from Britain. We have a Wimbledon champion from home. They conveniently forgot that in 1977, Virginia Wade won the Wimbledon title for them. Ignore it. When it came to the same Andy Murray in 1977, I think it was 2016 now, Andy Murray was again in the limelight because he got for Britain 2 Olympic gold medals for tennis. And that was hailed by them. But 2 Olympic gold medals in tennis was nothing. Both Venus Williams and Serena Williams have 4 gold medals each, Olympic gold medals. And yet, During the moment when the gold medals are given, they're all hailed. In a month after that, they're all forgotten. When it comes to statistics, you remember only what is done by the man. So, and the list goes on and on and on. You talk about, inherent biases. When you're talking about inherent biases, when you're talking about selections done, you're choosing people from among a crowd. Women are excluded. The New York Philharmonic Orchestra, all of you know that, the old Zubin Mehta's New York Philharmonic Orchestra did not have a female performer till the late 1970s. And at the end of 1970s, the beginning of 1980s, they slowly started inducting women performers. And today, the figure is close to 42% of the total symphony. Now you will ask what happened dramatically in 1979-80. The answer is very simple. It was blind auditions. Blind auditions, which means the persons who are conducting the auditions don't see the performers. They only hear it. And in that test, when the visual clues were not there, the talent of the women was spotted. And this is not only in music. You go to literature, many of the famous authors that you find who have come out with brilliant academic pieces on literature, they've actually palmed it off from their sisters or wives who have gone unnoticed. The academic world, do you know that even today, articles published by women academics do not get published very easily. Articles written by women academics do not get published very easily in the peer-reviewed journals. And in today's academia, getting something published in a peer-reviewed journal is so necessary. I mean, all of you must have at least come across those UGC guidelines where they start valuing you as your performance as an assistant professor, associate professor, professor based on certain guidelines. And one of the guidelines is that you have to have a minimum number of publications in peer-reviewed journals. And it's not in any journal, it has to be peer-reviewed journals. And what happens in a peer review? You have two people who are experts in the field, they take your papers, they go through it, and they find whether it is worthy of publication, whether it adds something new to the field, which is not already there. In that exercise, even there, the male version, the articles written by men get published. And that stopped, and there is some glimmer of hope now, only because even in academia, they introduced something called the double-blinded peer review. What is double-blinded now? You heard about the blind audition. What is double-blinded peer review? The double-blinded peer review is where the name of the author, as also the name of the person reviewing it, are both hidden. And then suddenly you have a large number of articles published by women making their appearance in the peer-reviewed journals. Now I ask you all, if this blinding in a selection process is something that can tilt the scales, as it has been done effectively the world over, if that blinding can actually tilt the scales, why don't we adopt that as one of the methods? In your application forms, every application form that you file here has columns which ask you to state A, your sex, B, your caste. And this is something that we can think of as introducing a change for the future. And I'm not talking here only about gender, I'm talking even about the caste. Why should we know these details for a job which does not require it? So these are ideas that can come on an understanding of what is actually the problem. And that is why I wanted you to think and wanted you to tell me what your views about the problem was. The short point is that when you construct a worldview based on one perspective alone and ignore the perspective of maybe half the population, then you're bound to have a system of knowledge accumulation which is fundamentally flawed. Your knowledge itself is flawed. And with that knowledge, you cannot hope to build a system or have governance which is not flawed. So that's the long and short of it. Now let's get to our constitution. We're talking about the constitutional perspectives. How does all of what I've stated now, how does it all fit into our constitution? We had a constituent assembly. Does anybody know how many members there were in the Constituent Assembly? 389. Do you know how many women? 15. Why 15 out of 389? And all these 15, mind you, were privileged people. They are not the persons who you actually want, affirmative action from the state for. These are not that kind of people. These are all privileged persons. But why this disparity in numbers? You might think that the male-female population ratio was drastically different way back in 1950, and when you compare it with 2020 or 21, it wasn't. The figures for 2020, the male-female ratio in our country is 108:100. In 1950, it was 105:100. Why then the disparity? The disparity is fundamentally related to the Constituent Assembly itself. The Constituent Assembly itself was comprised of members who were handpicked from the elected provincial legislatures. So when you had the provincial assemblies, where the elections were not on universal adult franchise, it was based on representative constituencies, the members were handpicked from those provincial assemblies and assembled together to form the Constituent Assembly. Now there is a version, there are critiques about the legitimacy of the Constitution itself, when it proudly says in the preamble, "We the people of India," and then ends with having given to ourselves this Constitution. Can we really say that these people, these 389 who were debating and discussing the various provisions of the Constitution, were actually representatives of the people of India? The recent constitutional text, Madhav Khosla has written about it. There is also an interesting book by a person called Tripurdaman Singh, which also says the same thing. They all critique the constitution of the Constituent Assembly and say that the Assembly never actually represented we, the people of India. But that's the story for another day. The point is that the general perception is that the Constituent Assembly did not represent the people of India. And if it did not represent the people of India, much less did it represent the women of India. And therefore, the flaws in the constitutional provisions are there to see, especially when you go through the debates. And by the way, if anybody of you all of you who have seriously gone through the Constituent Assembly debates, you will be flabbergasted by the kind of discussions that have happened. You'll be amazed at how certain provisions went through the assembly and found themselves entrenched in the Constitution. There are instances where there were persons who were speaking. What they were saying was in a particular language, which was not comprehensible to many of the others sitting there. Translations of those speeches were never given to the persons who were sitting. They therefore had absolutely no comments. And the motion was dismissed. So it was like going into an opera theater and watching an Italian opera without understanding a word of what was happening. So these difficulties or these anomalies contributed a lot to the provisions that we now find ourselves in the Constitution. And what does it actually do? It talks about equality of status and opportunity. There's very interesting debates in the Constituent Assembly debates, if you actually go through it. Very interesting discussion on the Uniform Civil Code. The Uniform Civil Code at that time, when the discussion started, the majority of the people who wanted it were the non-Muslim members. And also aided by the women members. They were all in support of the Uniform Civil Code. The Muslim members, of course, were opposed to it because they thought that in bringing in a Uniform Civil Code at this point in time, and we are talking 1950, which is immediately after the independence, bringing in a Uniform Civil Code at that stage, they thought would trample upon the cultural and religious rights of the various religions. And so they opposed it. But the women members wanted it because they somehow felt that this would be the answer to the problem of discrimination to women in the various religions. But it didn't happen. There was no concrete provision which introduced the Uniform Civil Code in our Constitution, as you all know. The provision found insertion in the Directive Principles of State Policy. Because at that point they said, let us not take a view one way or the other. We will leave it, and this is important. This is important for other reasons also, which I'm coming to. They said, we will leave this for decision by future parliaments. So it was, in a sense, a deliberate gap that was left in the Constitution to be filled in by future parliaments through political deliberation. Now, why I said this is important is, it shows you two things. One, there are many things. The guarantee of rights under the Constitution is envisaged in 1950 through an incremental process. It is not giving you a bag of rights on the next day. You must remember that we were, until the midnight of 15th of August, 1947, we were slaves. We were under colonial masters. The aspirations in the Constitution, the fundamental rights, are basically to clothe you with rights which were enjoyed by the Englishmen in England. Now this, when you're promising rights, when you're promising fundamental rights, you don't expect them to take effect overnight. You don't expect them to take effect overnight. So whatever could be implemented immediately overnight was implemented to the extent possible. What was left deferred was to be granted incrementally. So this incremental empowering of the citizenry is one cardinal feature that you find in our Constitution. The second, and more important, is that the deliberate silences that we maintained in the Constitution at the time of making it and adopting it was not supposed to be filled by the judiciary. It was to be filled through political deliberations. And therefore, it is with some concern that I actually see decisions of our Supreme Court and also from some of our high courts and also, extrajudicial utterances of various jurists in our country, when they say, following the American tradition and the tradition in American constitutional law, that the courts must fill in the gaps. Read into the silences is what they call it. Read into the silences of the Constitution. The Americans are doing that for a reason. The American Constitution has a specific provision therein which says that the enumeration of rights under this Constitution does not mean that the judiciary cannot read in other rights which are recognized from time to time. There is a specific provision under the American Constitution which allows the judiciary to read in rights. We don't have any such provision. How are we adopting the American approach while reading in the silences in our Constitution? So there's a gradual encroachment of the legislative process by the judiciary, and which is a cause for concern. Now, on the question of the feminist view with regard to the Uniform Civil Code, I may not be aligned to my brother Mushtaq because he is a strong votary of the Uniform Civil Code, as he showed it in a recent judgment of his. He even recommended it. But what I want to highlight here is, while the women members in the Constituent Assembly were in favor of a uniform civil code, modern day feminists, and you have the likes of Ratna Kapoor, Flavia Agnes, Nivedita Menon, all of them have come out and said, do not bring about this uniform civil code. And why? Because it will eat into the plurality and multicultural features of the Indian society. Multiculturalism, plurality, diversity is what is the essence of being Indian. And if you start bringing in a uniform civil code to do away with all that, then we are actually going against the idea of India. So that's the other view that has come in. So where do we stand now? And what do we do with regard to the empowerment of women? I can think of three ways of reforming our society to be more inclusive to women. And these are just stray thoughts. One, and this is what I would prefer, we see men and women as equal individuals, co-individuals in society. You recognize their individual autonomy, you recognize their individuality, and you amend your existing laws to fit in with that theory. But that's not easy. That's never easy. Amending a law is never easy, and more so in India. You all know the Vishaka example, which I always talk about. When the Supreme Court perceived of a problem in society, which is harassment of women at the workplace, they came out with guidelines in the Vishaka case, 1996-97. They said those guidelines were to remain in force till such time as the legislation, Parliament comes in with a law. Parliament came out with the law, 2013. 17 years is what it takes for the Parliament to take cue from what is said by the Supreme Court and enact a law. And it's not confined only to Vishaka case. In PUCL, talking about food security, again, the Supreme Court gave directions in 2000. The law came in 2010. So if this is going to be the time taken for bringing in legislation or even amending a statutory provision so as to make or to take care of a social evil, then we have to think of other means. And according to me, what lawyers and judges can do in the meanwhile is to interpret the existing laws through the lens of feminism. And this is important, and we have to do it. I mean, I've heard arguments, with all due respects to all the ladies in this room, I've heard arguments, but they're not from a feminist perspective. You're lamenting about what is happening to you. Those are arguments of sympathy. Don't do that. Never go that line. Claim it as a right. When you interpret a law, when you interpret a legal provision, your interpretation is similar to what I mentioned about theory. You have to see it differently. And when you see it differently, you will get a different meaning. Senior Advocate Simantri the other day was mentioning about the case that she did research on. And armed with all the UN conventions, she went before the most generous judge in our court. And sure enough, he favored her with an interim order. But the point to take away from that is that you start working up a case and projecting the case against a given legal provision, trying to persuade the judge to take a view which is peculiar or which is particular to the litigant who happens to be a woman. And now if you start thinking like that, you can actually bend any provision. It's not bending actually, that's a wrong word. You can actually use a provision. You can interpret a provision to align with a particular point of view. And it need not be a precedent to apply to the way, because men and women are different. They're two different individuals. Now you would, if it's a general proposition of law that you're laying down, then of course it applies to both. But if there is something that has to be, that is different, just as unequals cannot be treated equally, you have to bend the provisions to make it suitable for that. And that's something that not only the lawyers, but also the judges can do. So that's one way of doing it. And before I part with that, I'm also I'm not very happy with this clamor for numbers. Everybody says that if you want a greater representation, if you have a greater representation of women in any body, you will definitely have a greater chance of getting women-friendly laws. No. It's not enough if you just have women. You need women with the right perspective. I assure myself of an answer if I ask you ladies the question as to who do you think is the most anti-feminist in your own households. Many of you would say it is your mother. And it's a fact. And you can't blame her, because her knowledge is built from data which is fundamentally flawed and which is aligned to the male. And therefore, when you want to express your freedom and go out maybe to a theater at night, your mother steps down and says, no, that's not for a lady to go. So it's basically a flawed perspective. The second option is that we treat women as persons in need of special protection and therefore frame protective laws. And this is what we've done in the past. Provisions in the Abkari Act, provisions in the Factories Act, you find that women can't do certain kinds of jobs which are inherently hazardous. They can't do this, they can't do that beyond particular hours. That is also something that I don't favor, because you're treating women as inherently weak and therefore in need of protection. You can do it for a child, but not for a woman, and definitely not in today's world. And the third category of action which we can think of is affirmative state action. Now, this is something that can actually be pressed into service, because, as I said before, women have actually suffered years and years of oppression, primarily because of the flawed understanding of the world by men. It's a world created by men, for men. And therefore, the exclusion is a matter of oppression. And therefore, let there be affirmative state action in the form of reservation or whatever means, but limited period. Do not carry it on and on, because that again, there comes a stage where every reservation fails, or having achieved its object now has an adverse effect. So you have to time it well. And according to me, a combination of 1 and 3, where you recognize the individual, recognize the woman for her individuality, recognize her personal autonomy, and together with that, you also have affirmative state action for a limited period, so that you bring the women up to speed, you bring them into a society which is most egalitarian by that time, and then you would ensure the feminist aim of getting the women the social, political, and economic rights, the same social, political, economic rights as men. So I leave you with those thoughts. Reform of society through education, educating the masses. And the masses means you start from home. Take one of those Caroline books of the invisible woman. Circulate it to all in your neighborhood. Let them also get to know the truth about the world. And simultaneously, aim for an amendment of the laws and, in the meanwhile, interpret the laws in accordance with the feminist perspective. I thank you all for your patience. I'll be glad to take any questions if they come.
Hello, sir. I'm here on the far right end. I'm here on the far right
yes,
end.
yeah.
Hi. So basically, there are a couple of points I would like to disagree with you on.
Sure.
Yes, on what you have said. The most important point I feel is filling the gap,
Sorry,
filling
what?
the silences in the Constitution, right? That is not the function of the judiciary. And you had taken the example of Vishaka to show even when the judicial stepped in, the legislature took its own sweet time. Now, the POSH Act, or the Prevention of Sexual Harassment at Workplace Act, it came into force in 2014. In 2017, the Companies Act came up with a notification which said even if you have one employee, you need to implement the POSH Act in your company and then file it in your audit report. It is only in 2018 that the companies scrambled to have an ICC within their companies as such. And as far as the district level ICCs are concerned, it's a mess. They are not really implemented, no one cares. If a woman goes with a petition, it is not really heard and she's just called names, right? So my first disagreement comes with the fact that when we know how good a legislature works, and when we know it doesn't get implemented, now as a woman or as a person who's fighting for a gender justice, isn't judiciary our only remedy? Because where else do we go? Because as one of the fellow friend lawyer has stated before, if you go to the police also you're not treated right, right? So the executive, the judiciary or the legislature.
When I said silences to be filled, not to be filled by the judiciary, I was talking about silences in the Constitution, which is different from silences or gaps in the law, right? Silences in the Constitution. See, our Constitution goes on a principle of separation of powers. And the separation of powers principle is based on a functional separation or a functional separation of powers between the various organs. And it's not a simple trifurcation of legislature, executive, judiciary. It is more. You have the Comptroller, Auditor General, you have the Election Commission. So all these bodies are there together for a reason. And together they form, they discharge their roles of governance. Now, the problem when judiciary steps in and starts identifying gaps in the Constitution, which are left, the basic objection against judicial review in general, which is that the judiciary is composed of people who are unelected. So they're not the representatives of the people in a strict sense. So would it be wise to entrust policy decisions to people who are not elected, who have no sense of accountability to the public, and whose functional competence is in the craft of law? And what is it that we do in the craft of law? We interpret. We're masters at interpreting. And that is why the assigned role under the Constitution is for interpreting the provisions of the Constitution. So that's the silences they're talking about. Your other point with regard to the judiciary stepping in to fill the gap, that's valid, we're doing it. There is also, but having said that, of course you're right. If the other we function on a principle of checks and balances, and the checks and balances is designed specifically for this. When you have one or two organs of governance not acting, then the third must step in. And you find it across in all the provisions of the Constitution. The point I'm trying to say is, while that is desirable, when nobody else is there to act, the judiciary steps in and acts. That's fine. But there's a danger that everybody is missing out on. You see, if you look at Article 13, Article 13.2 says the state shall not make any law which infringes or takes away any of the fundamental rights in Part 3. Okay? Now, the judiciary is not a state for the purpose of 13. Why? Because traditionally it does not make law. It only interprets the law. The persons who make law are either the legislature or the executive. Executive also in times through ordinances, etc. So when the judiciary actually interprets the law, it's not making the law. And to that extent, it is not a state, except when it takes decisions on the administrative side. And then it has the trappings of a state. Now, if you actually read Golaknath and Keshavananda, and I'm sure many of you have not read Keshavananda, it's a lengthy judgment. Not anybody has the patience to sit and read it. I have, and therefore I can very authoritatively state it. The amending power, because Golaknath had actually said that Article 368, the amending power of Parliament follows a certain procedure, and on that procedure being followed, the Constitution stands amended. Now the question was, the amendment is always in the form of an Amendment Act. So it's an act, it's a legislation, it's a legislative activity, results in a legislation. The question was whether that amendment would come within the definition of law under Article 13 for assuming you could challenge it on the ground that it is violative of the fundamental rights. Golaknath said, yes, you can. Keshavananda said, no, you can't. And the reason why Keshavananda said that you can't is that they drew a distinction between a constituent power and a constituted power. Now, under the Constitution, you have the constituent power which brings into existence the Constitution. And in the Constitution, you have various authorities who are entrusted with various functions under the Constitution. They are called the constituted powers. The constituted powers, when it comes to legislation, enact these statutes and ordinary law. Keshavananda, they said, when Parliament amends the Act, and amends the Constitution under Article 368, it is basically an ordinary law. It is not a law in exercise of the constituent power. An ordinary law, just the reverse. They said it is an exercise of constituent power, it is not an ordinary law. And only ordinary law will come under the definition of law under Article 13, 12 and 13. Now this is fine as far as courts are sticking to their interpretative role. Now I ask you, suppose, like in Vishaka and in many other cases, the court crosses the boundary of interpreting a law and actually makes a law, even though temporarily, till such time as there is a statute that comes in. Would that not be law made by a state? Because a state as a concept comprises of the executive, legislature, judiciary, everybody. The words used in Article 13 are that the state shall not make law. Judiciary is excluded from state there only because it only interprets the law, traditionally. When it starts making the law, why can't it be subject to a challenge under if it offends Part 3? So there's a danger.
Which is why I think Vishaka is a guideline.
Vishaka is a guideline. You can call it what you want. That's all window dressing. You have to look at substantively what it is.
Yes, because that's what protected a lot of women in this country.
Correct. It has got the force of law. You can't disobey it. So it has got the force of law.
Technically it was called a guideline.
Correct.
Yes. So my second question to you is, when you said we should not look for women in numbers, but we should in fact look for capable women who can represent us adequately. Now my question to you is, for almost forever, as at least I can imagine, there have been men in numbers. The number of capable men or men of eminence or men deserving respect has been very low. But since they were able to reach through in thousands and 10,000s, we could find a few. Now, if you want us to search for a woman of eminence and then convince her to get on board, and then do this for us. So instead, sir, shouldn't our focus be that at least initially we put all the women in all the sectors or everywhere, in all jobs, in the legislature, in the judiciary, etc. So they get a chance of first learning the trade. Because here most of what happens is women are not allowed to learn the trade, right? We have several other responsibilities that we have to balance.
No, therefore the suggestion of affirmative action, state affirmative action. Because you need to bring up an oppressed category of people
Correct.
to a level where they can participate as equals in
But
society.
I also agree with you there that reservation is not the answer.
Reservation is not the answer. And the point that you were trying to make, or the objection that you had with regard to my quoting of numbers, you see, unlike the numbers of males, because we don't seem to have a problem now. We are fairly secure. We are trying to address a problem where the women actually need people who can project their point of view. Now, simply being born female will not help you do that. And therefore, if you're going by numbers, suppose you have a woman who is more aligned to the patriarchal views, you may as well have a man there.
That's very true. That's very true. So, but what I'm hoping is in numbers, we can, like swallow their voices down, right? Because right now what I feel is the trend is more about women learning about their rights, women knowing they have rights.
No, look at it this way. Suppose you have a system of voting on a particular issue, and you have women who are more aligned to patriarchal system. How does the numbers help you?
So, but if there was 98 men and 2 women, how does her voice matter anyway? How does her voice matter anyway? Because if there is 98 men who are voting on an issue and 2 women standing on the other side, it does not matter.
No, you're conveniently forgetting that you can have people like me also sitting and voting for the women.
Which is why I said men of eminence, men deserving respect are rare and few. But yeah, okay, I'll leave it to the others.
Good afternoon, sir. Just continuing with what Raga was saying, actually, when we talk about women in numbers, the thing is, the fact that, like I'll just give an example of the family court. We don't have a toilet there. And why we don't have a toilet, and we have a lot of women coming there, a lot of women lawyers, there's a women judge also. Right now we have a women judge. But the fact that there is no toilet is something which has not struck anyone.
Correct.
And that, so I feel when we're talking about that, someone has decided, the administrative committee, right now there's been a reconstruction happening, and there's been a modification, but still there's no toilet. And the thing is, when we're talking about this, because the fact that we need toilet has to be decided by the administrative committee. The administrative committee, I don't know who is part of the administrative committee, whether there were women as part of the administrative committee or not, or whether how many women are there or not, it's a different matter. But the fact that for a woman to it sounds so basic that no one even talks about it. It's so taken for granted that, okay, whether we'll have a toilet, or not is not at all. I don't think we discuss about it at all.
They don't. You're absolutely right. Because, you see, it's basic. Satya, it's basically the same problem. You don't have the data. And the projection is not... See, the clamor is more for appointing a person a woman in the committee. That's not what you should be doing. Instead, project the cause.
Yeah,
I'll give you an example, because I was holding charge over Alleppey district. I was the portfolio judge for Alleppey district. And this was something that I asked them, because at that point in time, Alleppey district had a woman district judge. So I asked her, do you have sufficient toilets in your court complexes for women? And she said no. And then I asked her, do you have sanitary pad vending machines, dispensing machines? The answer was no. It took me less than 2 hours to arrange for these. except the buildings. The vending machines all went there.
So, but there are very few
So
people
it is,
who think like that.
it is a matter of perspective. I'm only saying
That-
it's not in numbers, and it's not identifying the sex of the person and appointing her to a committee. That doesn't help.
But
You have to
also-
project the perspective.
But also, I feel, Your Lordship, sir, the thing is that, women who follow the patriarchal system also, I feel it's more of negotiating their own spaces.
Correct.
Because women who decide to challenge the patriarchal system are left alone. So are isolated. So when they are isolated, people rather like, why should I, get myself into the limelight and get myself into trouble? I'd rather keep quiet and let
No,
it
but
go the way it should be.
Let me
So
ask you.
that's-
Let me ask you a very frank question. Who are the people isolating you? Other women.
Yeah, but that also is because it is being
That's the
supported.
problem. That's the problem.
That-
So address that.
It's
See, because
it's
you
more of
never-
I feel that's like we talk about women versus women, or women are the ones who are actually enemies of women. But I feel it's like the women who are following the patriarchal system and
Correct.
trying to isolate are also, they feel more confident because they have the support of the silent men who are there.
Correct.
Because I
So you
feel
can-
I feel people like you, like who have this kind of perspective, are very few in number, and
No,
I
but
feel, I
it-
feel that
I
like
think more
lot of-
than educating men on the nuances of femininity, I think you need to inculcate more feminism into your own, category.
Once you get support, Your Lordship, sir, because I feel that people like us who've been able to speak or who can come forward are able to do so because we've got support from the men in our family.
Correct.
And that makes us more confident. And I feel that the men in the family, if they give the support, you feel more confident and you can come ahead. I mean, for me, actually, I remember, like when we are talking about when we started off practice, I remember this was in the 90s, 98, 99, that period. I feel most women used to leave office by around 6 o'clock and 7 o'clock. And sometimes, like if I used to reach home by 7:30, my parents would get worried and wondered why I'm getting late because it was dark. But now if you see, this is 2022 and we have women working so late in office. I mean, they would stay at 11 o'clock, or also some offices, they'll stay at 11 o'clock also, and they don't mind. And it's taken, and it's okay. But it's taken how many years? Almost 20 years for that change to happen.
See, because you're talking about changing a mindset.
Yeah,
That doesn't happen overnight.
So when we talk about affirmative action also, when we talk about reservation, that affirmative action, there can't be a time limit because it's
No.
taken 20 years for reaching at least this point. So how many more years?
I never said that you should stop in 2 years or 3 years. Take whatever time is required, but don't stretch it beyond that. Because there is an optimum. Once you reach that, then it's always downhill. Excessive reservation is also bad, because that leads to adverse discrimination, and that's worse. The other point which you were talking about, male support and families. You see, you have to change the manner in which you get your representation in policy-making bodies. Now, take for example your even the association. You have, I believe, a woman representative also two women representatives. How are they elected? What is the... Correct, but who elects them? All the members, men and women. Correct. So you're going to get a skewed perspective there, because the men will not understand the reason why this person is there. He may just like the person and vote. But if you want to have a woman's perspective on the policy-making body, then you have to have a representative who's elected only by women or people with similar perspective. Because you will be able to identify one among you who can carry this message forward and who can influence the decisions in that body. You need an effective representation in that body. So minor tweaks in our existing systems, which are all, you name any system now, it is designed with the male in mind. And that has to change. And we're not talking about India, we're talking, do you know where the worst kind of discrimination in employment happens? In Silicon Valley. The maternity leave granted to people, to women in IT sector is the worst in America. We are much better with the kind of benefits that is given. So it's not something that is confined to, and we are talking about universal adult franchise, etc. We've had women as prime ministers. We've had women in top slots in our country for a good number of years now. Has America ever had a women president? They would balk at the idea. No matter what they say about women's liberation and talk about feminism, it doesn't translate into reality, it doesn't translate into action. So this is all idle talk. Yes, Anaka.
So just to carry forward the discussions that we've been having, just my perspective on it. When you said that it is not enough just to have women in numbers, I thought you were very right in saying so. In the sense that if women are in two capacities, one, as you said, mere puppets, in which case they are not really representing the cause for which they are there. But on the other hand, we may sometimes have people who are incapable or not the most appropriate fit for the job, and they are just there to fill the numbers. So what happens is, I think, you know how in society I take the example of somebody on the road driving a car. We see numerous instances of the traffic rules being violated. But then if there is an instance of traffic rule violated and behind the wheel is the lady, they're like that answers everything. So that is the perspective. So when we have women in roles, and sometimes possibly it is not the right decision or the right fit that they do, it is like reinforcing the societal norm that women are not good or this is not meant for women. And that, I think, works counterproductive. But on the flip side, as the lady advocates were saying, we are in a society where women have a lot of difficulties to come forward. So without meeting those societal norms, we are not going to be having so many women who are capable or at par with men. So it runs in a vicious circle. So I just wanted to ask from you, sir, what do you think is the immediate way forward? Because when we come back to social reform, it's a long drawn process. But if it is just women in number also, that also doesn't work.
See, what I would think as an immediate first step, you're right in saying that, there's a change in mindset required, therefore mere numbers is not enough. And to get people or even women into that mindset or state of mind, you need some time. But what can be done immediately is at least remove those things that cloud your vision. I was talking about the example of the application forms, blind reviews, blind selections. See, if there can be some kind of immediate step taken to blind the selector to the gender, which is causing the bias.
So do you think,
you can have an assessment, you can have a blind assessment.
So that brings me to the next question, sir. Do you think that as a society we are ready today to move to a stage where gender or sex is not the identifying criteria? Because women, however much we wish to disagree with it, the strongest identifying characteristic about her is her sex. And I think that in itself could be quite discriminatory. So do you think that both men and women that we as a society are ready to move to a stage where we should keep sex aside for a moment and just look at personalities. But is it
I think we've
new a
already
concept?
done that, haven't we? When we recognized the third gender, when we recognized the third gender and actually gave them rights through a decision of the Supreme Court. So things are moving, to answer your question. The question is, how fast will they move forward? Again, you need to have steps taken which will accelerate the movement. And what I just suggested was one of them. If you eliminate the biases which are inherent in any selection process of people to man policy-making bodies, then you have a fair chance of real talent getting attracted there. So if you have a blind selection of members to maybe a policy-making body, right? Without the application mentioning whether it is male or female, like what is happening in the academia. I was telling you about the double-blind review. So if you scratch out the names, you just have the qualifications. This is candidate A, candidate B. You know, in the academic world, they have even gone to the extent of saying, putting the first name, they mention only the last name because the last name would be that of the father, so which would be a male name. The first name, so it would be P. Smith, and they would just put P. P could be Paul or P could be Pauline. So you have only P mentioned in the article, so then you would not know whether it is written by a male or a female. So simple tweaks like that could go a long way in trying to reduce the inherent bias that is there in any system.
But the inherent danger in that strategy being that the way that our society is today, women might not even get there in the first place because they may, if the risk being that if it is a blind selection, possibly women will not be there even in the numbers that we see today.
No, I mean, we are talking about where there is merit, but you are being disadvantaged only because you're a woman. That's the bias.
So this should be coupled with reservation.
No, of course. I mean, you have to have the merit because now the women you have women fighter pilots also. So it's not as though there are glass ceilings there which operate on an inherent bias. It's that which you need to address. So you remove that or you try to mask that, your chances of entry into the public sphere are more. And that's what we need to address. That's what we need to address now. Legislation, as we all know, in our country takes time. And it will happen. But in the meanwhile, we'll have to, as lawyers, judges, we need to interpret the laws in such a way. Slowly that transforms into a regular affair in society. Taking note of those changes in society, now we have legislation coming in. So that takes time.
So just to put it, just in my understanding, is what you're trying to say, sir, is when it comes to the general category, keep it
broad-based.
Broad-based and no identities are revealed. But then continue, parallelly also have the reservations intact so that the numbers are also met.
Yeah.
Thank you, sir.
Good evening, sir. So since you yourself had said that how interpretation of law is what matters, and since you are one among of the people who interpret the law itself, what according to you is a barrier that has caused such a lag in the interpretation of the law in a manner that is equivalent to both genders? As in, why have we interpreted the law only in a partial manner until now? And why are we so late?
It's the same reason which I started off my lecture with. It is your basic flawed understanding or flawed knowledge that you have because of the data bias. So when you grow up on a nutrition of distorted facts, your knowledge is bound to be distorted as well. And it is using that knowledge that you start interpreting the laws. So you're automatically aligned to a male perspective. And just to highlight on that, I mean, it's not, and to also, buttress the point which I was making about just having women. I mean, you all know the case of the POCSO case where a lady judge of the Bombay High Court interpreted something in a manner which was which no man would do. So, I mean, I rest my case on numbers.
So I have one more question. So we've had a talk about gender justice and constitutional perspectives, but what we've talked about mostly here is the upliftment of women with regards to justice and constitutional perspectives. So don't you think young men are also sidelined in the process as well as, and we've seen instances where men have been exploited by special protection that's been given to women?
Sorry, you're not very clear. What? I didn't get the last bit.
Yes, sir. So don't you think that young men are sidelined in the process of upliftment of women itself, and by creating special laws for the protection of women? And don't you think that also is also a barrier as to that incomplete inclusion of men and incomplete inclusion of both genders rather than only women? Isn't that also a reason as to creating a barrier as to both genders thinking that gender justice is in fact important for both genders? As in, why are when you talk about gender justice, why are we only talking about women and not men? So we had an entire conversation for an hour, mostly about upliftment of women and not men.
I admire your courage. May I ask how old you are?
So 21.
So you've got years to live unless you want it cut short. Have you taken a head count of the number of women here?
Yeah, sir, I agree with the fact that the degree of injustice is in fact greater for women. But is that also not,
It is. To answer your question, jokes apart, I think it's important that attention is also paid, and this is where mothers in every family have an important role to play. Does not understand the feminist perspective is very remote. Very remote. Because you must understand the psychology of a child. I mean, even when you're an adult, why? When you're old and you fall down, you say Amme. That's the first sound that comes to you, or the first thought that comes to you. So the respect is so deeply ingrained in your consciousness that it is very difficult to disobey or not pay heed to a mother's advice. And if the mothers perform their role correctly, I don't think we have reason to worry about the next generation. And it's a respect for, it is basically an issue of tolerance. It is basically an issue of showing respect to the other, recognizing the other. The male and the female, what has happened so far is that we always see the women as the other, or maybe even sometimes the significant other, but it's still the other. And that has to go. You don't treat them as the other. You treat them as part of yourself. It's another individual, another citizen coexisting with you in society. And the minute you start respecting that, I think you will automatically reform yourself if you've not done so already.
Thank you, sir.
Again, it's the problem with numbers. But sitting where we are in the Kerala High Court, I think we've done fairly well in that area, because we have, we boast about having given to the country the first women judge, the first woman Supreme Court judge. There are many firsts when it comes to women, and we also today have 6 judges, women judges. And they were here, by the way. I don't know whether you saw them.
Good evening, sir. Just to explore a slightly different narrative here. I'm wanting to seek your perspective on gender justice from an LGBTQ plus perspective. And specifically in that, I'm wanting to understand what the role would be of the executive court, which we have seen a considerable rise of, particularly that of the High Court and the Supreme Court in the past half a decade or so, in bridging the gap between Navtej Singh, and which decriminalized the offense in 377, and the landmark judgment in Obergefell v. Hodges, which realized the ultimate dream in the United States of America, which is marriage. And I specifically, dare I say, put this burden on the High Courts and the Supreme Court because, I mean, living in the circumstances that we do, wherein we have subcultures, where we have rudimentary urban and rural subcultures that are so prejudiced that there is no reliance that can be placed on the government to effectively come out with policy. And I'm not even for a minute suggesting that the judiciary emerge with policy, but insofar as even suo motu actions are concerned, what would be the role of the executive gap in providing an equal space, even in terms of at least humanitarian rights for the LGBTQ plus community?
I think, Pooja, we're basically assuming that there is a gap. Let me start with that. Because when you talk about the gap to be filled with regard to, one, you've decriminalized homosexuality, and now you want to take it to the Obergefell level where you're talking about same-sex marriages. The question we need to ask is, what is our concept, what is our idea of marriage? Because there's no harm in two people living together. There's no, homosexuality has been decriminalized. Two consenting adults can live together and they can live just as much as a family. So what is this, what is the magic that happens with a union in a marriage? Now, even in Obergefell, if you look at the Supreme Court decision, the primary consideration by the Supreme Court in recognizing same-sex marriages was the interests of the children. They did not want persons who had adopted children and who were living as same-sex couples to be identity-less or to be illegitimized. So, for the sake of giving a parentage to the children, there was perceived necessity for recognizing a union of same-sex marriage. So that's the Western tradition for you. But we have to ask ourselves whether we need that here. Because it's not as though illegitimate children don't have rights. Our succession laws do recognize them. And therefore, there is no magic that happens with the conferment of a legitimacy through the marriage of the parents. And parent, I mean same-sex parents. Now, when you talk about, our laws have also developed to the extent of not insisting on the name of a father whenever there's an application preferred by a child for getting any of the services of the state. So, I'm a little worried when you talk about a gap, because a gap always presupposes an objective, a present state, and the gap in between. My question is, do we really need that objective? Considering that we've come this far, and we've reached a stage where you're recognizing same-sex unions and same-sex cohabitation, the legitimacy of children adopted by them, not an issue, because the child can have its own individuality, personal autonomy, it can get any document in its name, it does not have to disclose the name of a father. And a name of a mother, obviously, it will have. So, if the law already protects their interests, yes, why go in for marriage?
Yes, I appreciate, sir. I was only speaking of it, for example, if you think of it in terms of a child, or if you think of it in terms of the idea that a union is already accepted, so why is recognition of a marriage required? From my perspective, that would be approaching marriage as a right from a justification point of view, as in why is it required at all? Because at the end of the day, you have all of these rights.
Exactly.
But I would say that, I would argue that it is a little bit more preliminary than that, in the sense, the same way I am desirous of getting married, I could have a homosexual friend who is desirous of getting married.
So
I would argue that
the question is, what is it that you seek to achieve through the marriage?
The legal sanctity that marriage comes with.
It doesn't have any sanctity anymore. There is nothing more that marriage adds by way of legal sanctity than what you need. What do you require a marriage, sanctity of a marriage for? What do you use using your marriage certificate?
No, sir, it was never from what is it for. It is just, can I?
I mean, if it's just a question of, waving around a piece of paper saying signed by somebody that both of you are married, I think
yes, I understand.
It's basically a question of insecurity. Because I'm married to somebody and he and I know it. Why would I want a third person to endorse that?
Yes, I understand. Thank you. Yeah.
No, which is what I said, because there may be certain religious laws or personal laws which prohibit that. For them, maybe you need it. But otherwise, I don't see a necessity for universalizing this concept of marriage, especially the way it is going. I don't see any more sanctity in a marriage.
Good evening, sir. So, while talking about parenting, we all know that a good amount of children are brought up by their mother. So, while mentioning the mother, it's a female, we all know that. So, if all these devil beliefs, like discrimination, is inherited to a child, whether it be a boy or a girl, so who do you think they got it from? Like all these teachings, is it from their mother or their father or the society? And if it is so, like if it is from the mother, who is the biggest enemy, or who is the person who stands against feminism the most?
See, feminism as a mindset, I don't think is an inherited quality. See, you can have a mother who's probably not a feminist. You can have a father who's certainly not a feminist. But you could have the child who, it's a basic distinction between nurture and nature. There are certain qualities that you imbibe through nurture. But nature, your environment is what molds you as a person. And in that process, you can have an imbibing of ideas. As I said, feminism is a theory, and theory means to see. You can have a vision of yourself. As an individual, you can grow up moving in the right circles. You can have ideas. Your friends could impart ideas to you, and you may find that appealing.
But sir, there can't be any specific age where we start getting all these theories or ideas.
No, what is the specific age when you started acquiring knowledge?
Yeah, that's what I'm saying.
There is no age.
It could be from the household or the society. So who do you think who is like?
There's no fixed formula.
Okay. Thanks, sir.
There are households where the man is more feminine than the woman, or feminist in his thinking.
No, I just want to add one sentence. When Supreme Court has identified the right of transgenders, they use the word third gender. I think that is highly indiscriminatory, which was pointed out by many. And we should not repeat that, because even then we are thinking that men are first gender, women are second gender, and some others are third genders.
You're right. I would agree with you. I would rather have the law stated as, irrespective of the sex that is assigned to the person when he or she is born, you need to grow up and identify yourself as either man or woman. Because ultimately it's the identity that you choose, and that can only be one or the other. Thank you. And that's definitely a point that you make there, because you're bringing in a third gender. You're basically creating more segregation. and that should not be done. When it is not required to be done, because ultimately the transgender male thinks that she is a male, and of course they say he, she, they. Why have this distinction? Because admittedly they think that they're male. They think like males. So call them a male.
Extremely happy for the healthy and effective interactions. But due to the paucity of time, I think we have to end up. But all the same, we can ask a question, perhaps the last one of the session today.
Good evening, sir. So I had a question. Does women itself demarcate our own position, like comparing ourselves with men? Or should we actually look into our own abilities? I'll just cite an example. Like in our college, for our hostels, we had this time for entering our hostels, that is 8:30. So one of the arguments raised by my friend was, boys hostel have time till 10:30. Why not ladies hostel have time till 10:30? So does women itself demarcate our abilities just by comparing ourselves with men? So is it right to compare ourselves? What do you think? Should women...
I wouldn't compare, I wouldn't feel comfortable allowing you to compare yourself with a man. Because that is the flaw that has informed our knowledge gaining mechanism from time immemorial. You see, in Western world, the woman is always considered as the other of man, right? Yes. And this whole perspective of seeing the woman as other than man or something that is not man is what they call the phallocentric view. Phallus, the male phallus, and the woman is always identified as a body that does not have a phallus. That's called the phallocentric view. And that is past. I mean, we're not talking about that anymore.
Yes, sir, because I just heard in the first question, because there's the comparison between men. Men can do this, men can do that, why not women? So are we itself demarcating our abilities, our qualities, just by comparing with men? That's the question.
You should ideally start with the riddle of why there is men and women. In women, you do have men.
Yes.
Get rid of that also.
Yes. Thank you, sir.
So just the last question. So in the context of the blind review that we talked about and the entire discussion of masking the disadvantage of being woman, whether it be in literature or any other field, so do you personally believe that it would alter the mentality behind the person behind, or it's just a short-term recourse?
No, it is not altering the state of mind at all. Yeah. In fact, what you're doing is deceiving the person who's actually doing the review into thinking that he's actually, if he's got a bias, you're deceiving him into thinking that this is actually by a male. Because by default, the thinking assumes it is male. So what we're doing here through a blind review is basically removing the opportunity of bias or removing the chance of bias. You have a bias only when you have a particular object in front towards which you lean and you want to do something in favor of that person. Put a screen in between, you don't know who you're talking with.
So, but would that bring a long-term results per se?
It is not a long-term, it's not desirable because there's an element of deception in it.
Yes, sir.
But then your generation of people with Facebook and multiple profiles, false profiles, should not be averse to such ideas.
All right, so thank you, sir.
Done? Thank you.
On behalf of all of you present here, let me take this opportunity to thank Honorable Justice Jayashankan Nambiar for the expertise he has shared with us. So as you said, gender is not just male or female. It's a social construct and identity that which we gain as we grow. And you also said that the world was interpreted or is being interpreted from a male perspective. And the reason for gender bias, as you said, is that the lesson we get in history is flawed. And the ways that you suggested for inclusiveness of women includes interpret laws from the lens of feminism, affirmative state action, and reform the society by educating the masses. So I think it's time that we stop hoping for somebody else to do something for us and to do away with all the concepts or the lessons that were forced upon us. It's time that we start seeing the world from our perspective, from a woman perspective. Thank you, sir, for enlightening us. Now, let me take this opportunity to thank the chairman, Kerala Legal Service Committee, for organizing this session. And let me also thank all the judges who were present here, and also all of you, with your presence, with your active participation, and made this a wonderful evening. Thank you.